Former FCC Commissioner Robert McDowell with us right now to react to all of this. Commissioner, what do you make of it?
Well, first of all, the rules aren't going away, so that's something that gets repeated over and over again in news stories. And what we're doing is actually, what's happening here is reverting back to the Clinton-Gore administration legal framework. That's where the Federal Trade Commission and Department of Justice still police anti-competitive conduct under things like the Clayton Act, the Sherman Act, the Federal Trade Commission Act. So internet service providers can't charge you, uncompetitive or anti-competitive exclusive type charges for faster service that would harm competition. They can't do the blocking and the throttling that's always alleged with these stories. It gets very frustrating to hear this time and again.
Can they pick and choose the speed at which certain material is downloaded to you?
Not in an anti-competitive way, no. Just by doing something exclusive like that. So favoritism, let's say one internet service provider having a favorite content provider, let's say, that'd be a per se violation of antitrust law. So that's why before February 26th of 2015, before these Title II rules that have been sort of dumbed down to be called net neutrality, before they were in place, that's why you had this amazing entrepreneurial explosion of brilliance throughout the internet ecosphere, where an idea that was hatched in a dorm room could end up being one of the world's largest companies. Why was that? Well, because of the legal and regulatory framework that was there, plus the low barriers to entry and all the market conditions that allowed for that. So what the FCC did when it voted last December 14th, with the rules that take effect today, is just to go back to those Clinton-Gore administration policies, which worked so well. So it gets confusing to folks when it gets reported that somehow consumers or startups are not protected. They are protected. The internet was not born in 2015. It was born long before that.
I understand that, Commissioner, but I'm wondering now, especially in light of waiting for word officially whether the AT&T and Time Warner merger could go through. Let's say it does go through. Wouldn't AT&T be more apt to prefer Time Warner programming and speed that to me than any competitive programming? Wouldn't it be, as things stand now, within its rights to do so?
Yeah, no, actually not in an anti-competitive way. It'd be in violation of competition and antitrust law, number one. Number two, it wouldn't have an economic incentive to do that. This is an $85 billion merger. You correct me if I'm wrong, you're in the content business, but your content's more valuable the more people who watch your program, not if fewer people watch it. So you're not going to buy an $85 billion company and then devalue it by having fewer people watch your content, by restricting access. So the incentives are there.
Unless you favor your own content, right?
Right, and then all of a sudden you become less valuable, right? Then your stock price crashes and your whole business concept is destroyed.
So you don't see, in other words, that was the kind of paramount, fear, Commissioner, that all of a sudden this would give free license to the guys who control all the pipes to prefer what they want coming down those pipes and not what you want.
Right, well, remember when Time Warner Inc., Twix as we call it, by its ticker symbol, and Time Warner Cable, TWC, were one company, they didn't do that. The end of the world was supposed to come when AOL and Time Warner merged in the late 90s and early 2000s, and that didn't happen either, with all these same arguments. And why is that? Well, A, the legal framework, and B, the economic incentives just aren't there for that to happen. And it hasn't happened with Comcast,
so
NBC,
could I
Universal
ask you about
either.
the AT&T Time Warner situation? Do you see it looks like it would go through? Maybe not. It could be a naive read on my part. Because if it doesn't, it changes a lot of dynamics for a lot of deals that could be pending, including Comcast sniffing around.
Yeah, no, I think, first of all, the government had the burden of proof here in this trial, and that's a very steep hill to climb. This is the first lawsuit to oppose a vertical deal in 47 years, almost half a century. And there's a reason for that. It's hard to prove that there's going to be a consumer harm or that consumer welfare will be harmed by doing this. And I think the AT&T, or the government, I should say, the government witnesses were really kind of destroyed on cross-examination in terms of what is the underlying theory here for saying that this content is going to be more valuable if fewer people watch it, that there's an economic incentive to do that. Now, we'll see. Anything can happen, I guess, here in Washington, and has. But Judge Leon, the judge in charge, is very much a law and order, facts and law type judge, no nonsense. And I think he'll make an intelligent, well-reasoned decision here.
All right. We'll know later on. Robert, thank you very much for taking the time.
Thank you for having me back.
All right, Robert McDowell.